Go ahead.
Go ahead. I mean, are you saying now that there is an interest and a compelling interest in racial diversity among other kinds of diversity? I mean, putting Harvard's, whether Harvard should be more socioeconomically diverse, probably should be. But putting that, I mean, is there an interest in racial diversity?
I agree with my colleague, not a compelling interest that could justify a racial classification. But racial diversity is not a bad thing. It is a great thing. It is something.
But the whole premise of this, right, and, we can talk about whether these programs are narrowly tailored, whether the universities have done enough to, with the use of race-neutral criteria. But the premise of your argument is that even if race-neutral criteria could not achieve the object, Harvard can't use race-conscious criteria. And that must be because you think it's just not important enough. Isn't that right?
I don't think that's right. So we have very detailed record evidence here that if Harvard just turned off race on its admissions process, it would still have 6% African Americans, I believe it's 9% Hispanics, so 15% underrepresented.
So you think good enough. But how about if it were 2%? I mean, the nature of your argument is that it doesn't matter. That's what the nature of your argument is.
I disagree, Justice Kagan. It does matter because if you're below those numbers, then Harvard's probably discriminating in some sense, and it should stop. Or it's not reaching underrepresented minorities in the way that it should. Perhaps it should not.
Well, that's just fighting the question. I mean, the question is, is there a limit beyond which you would say, oh, yes, if you can't achieve that level of diversity with race-neutral criteria, then you're allowed to use race-conscious criteria?
I don't think there's any level that justifies explicit racial classifications, but I'm going to fight the hypothetical one more time if you'll let me, because race-neutral alternatives. No, I don't think I will. So let me just go on and ask you a couple of other things. I mean, because this is, to me, this is a lot of the argument here is about a university has a compelling interest in collecting a diverse class, including along racial dimensions, and maybe especially along racial dimensions, given the kinds of challenges that our society faces, in the exact same way that all the other institutions of our society does. So I'm just going to ask you some questions about that. If you're a hospital and you serve a diverse group of patients, is it super important to you to have a diverse set of doctors? I don't know that the evidence about the diversity of doctors and patients or anything about the medical field.
It wouldn't matter, yeah. Okay, or maybe it would, you don't know. If you're a police department and you serve a diverse community, is it super important to you to have a diverse set of police officers?
I mean, I believe that's important if there's good evidence that a racial classification was needed. That has nothing to do with the educational benefits of diversity in universities. That's the interest that Grutter
Do you
upheld.
think that if you're a law firm, or if you're a judge, and you want to have a diverse set of clerks, do you think a judge can't think about that in making clerkship decisions?
Absolutely can think about it. This court's decision in Feeney says knowledge of race is not the violation. It is using it as a factor to distinguish them.
Let's say a judge says, I want a diverse set of clerks. That's, I want clerks who would, grade on any number of criteria, but I also want a diverse set of clerks. So over the years, people will look at that and they'll say, there are Asian Americans there, there are Hispanics there, there are African Americans there, as well as there are whites there. Can a judge not do that?
I mean, I think that is a admirable goal. I don't think a judge could implement that goal by putting a thumb on the scale against Asian applicants or giving a big preference to Black and Hispanic applicants. I think you need to treat people equally based on race, just as you're not going to hold my race against me in judging the quality of my arguments. I think racial diversity is important because it's a good metric to make sure our institutions are equally open. And you can certainly be concerned about that. But the question is using racial classification, telling people that you didn't get the clerkship because of your race.
Yeah, but the point here is, look, everybody would rather achieve all our racial diversity goals through race-neutral means. Everybody would rather that. And that's certainly what our cases say you have to do. The question is, when the race-neutral means don't get you there, are you prevented from taking race into account in all those ways that I said? And I could add a dozen more. Businesses who find it necessary, in order to achieve their economic objectives. to have racially diverse workforces. I mean, I could go on and on and on. And the question is, when race-neutral means can't get you there, don't get you there, when you've tried and they still won't get you there, can you go race-conscious?
I don't believe so, Justice Kagan, and I think this court has already said in Parents Involved that racial diversity is not a compelling interest. It is overall diversity of all kinds on college campuses. And this doesn't have to be hypothetical. We presented an alternative to Harvard that would achieve socioeconomic diversity for the first time, that would boost underrepresented minority representation, that would lower the number of white students on campus. And so we're talking not about no diversity and diversity, we're talking about 10% black representation or 14% black.
I take this to be the purport of most of your briefs, not putting aside the last 10 pages or so. But in your view, it really wouldn't matter if there was a precipitous decline in minority admissions, African American, Hispanic, one or the other. If I think there are some numbers in this case, but suppose that it just fell through the floor. Would it just, too bad?
Well, I don't think that it's going to fall through the floor if the university is actually committed to the broader diversity it wants. Because
right, I know you think that, and there's been obviously a lot of the litigation has been about that. How much will it decline, and you're expert and they're expert. But the logic of your position suggests that that really doesn't matter. I mean, the last 10 pages of your brief where you say, has there been narrow tailoring here, it matters in that 10 pages. But it doesn't matter if you're saying there's a categorical rule, no race shall be involved in admissions decisions, then it doesn't matter if minority enrollment or particular kinds of minority enrollment fall through the floor, does it?
If the application process is open and that is a result of the criteria that the university has elected to choose, and it's not discriminatory under this court's other precedents, then that is the educational decision the university has made. I doubt any university would ever make that decision. That has not been the experience, for example, in Florida, which is race neutral, has very similar demographics to UNC, and by UNC's own admission in this record, actually achieves better racial diversity as well as 50% greater number of programs.
Right, well, that
on
gets
campus.
us back to this question of what universities can do with what purpose to achieve racial diversity even without being explicit about racial classifications. But putting that aside, I mean, I guess what I'm saying is your brief, and this is very explicit in your brief, is like it just doesn't matter if our institutions look like America. You say this on page 11 in your reply brief. And I guess what I'm asking you is, doesn't it? I mean, doesn't it? These are the pipelines to leadership in our society. It might be military leadership. It might be business leadership. It might be leadership in the law. It might be leadership in all kinds of different areas. Universities are the pipeline to that leadership. Now, if universities are not racially diverse and your rule suggests that it doesn't matter, well, then all of those institutions are not going to be racially diverse either. And I thought that part of what it meant to be an American and to believe in American pluralism is that actually our institutions, are reflective of who we are as a people in all our variety.
I think that's right. I think the reason that we think that and why that is a great American ideal is because we expect that the government is going to be open to everybody who wishes to apply, and that because merit and your worth as a person and your value as a contributory citizen is not correlated with your skin color. And so naturally, a government that treats people fairly and that makes opportunity open to all will necessarily see racial diversity.
But Mr.
And indeed, that's been the experience
you said,
before.
and I think you're right to say this, you said to one of my colleagues' questions, if this didn't matter, they're spending an awful lot of time and money and anxiety doing something that doesn't matter. So let's presume it does matter. Let's presume it does matter that these programs have been understood to be necessary to ensure that these institutions have a certain level of racial diversity. And I concede what Justice Gorsuch says, that racial diversity and quotas, it's a little bit mysterious, but have a certain level of racial diversity that will enable them to get the benefits of all our many different peoples, and that enables American society generally to do the same.
Well, because I think one of the problems with Grutter is that it suggests that this is somehow costless, that if it's one factor among many and we can't identify, exactly how many points race is getting, although obviously statistical analysis does allow us to do that at some point, Grutter says it's not that big of a deal. It's always a plus factor and never a negative. But this is a zero-sum game. That is one of the problems with Grutter, is it suggests that the harm of racial classifications, which this court have always recognized are inherent and invidious of themselves, can be hidden or pushed down as long as race is just one of many factors.
And why can't you do it through race-neutral means? Because I think everybody has agreed, all our cases indicate that race-neutral means are better if one can achieve those kinds of objects that you were talking about that way. So why can't you after 20 years?
It's absolutely correct that it's incumbent on universities and on the service academies to take account of race-neutral alternatives and to put those into practice where they can achieve diversity. And that's what the service academies are doing. They have done things like trying to bolster outreach efforts to underserved communities, to try to solicit additional nominations from congressional districts that have traditionally sent fewer cadets to the academy. They've looked into other alternatives like socioeconomic preferences, but West Point discovered that that would actually increase the number of white men at the academy. And other race-neutral alternatives just don't work in this context for the service academies. For example, a top 10% plan wouldn't work because the service academies have to draw from a nationwide applicant pool, and they also have to prioritize and value other characteristics like physical fitness and leadership potential. So I can't say that we are able to get there all the way right now with race-neutral alternatives. That's what the service academies have seriously studied, but we are trying to make progress toward that goal.